Hi, everybody. Welcome to episode 235 of the Immigration Lawyers Podcast. Thanks for joining. We have a regular monthly episode with Kevin Gregg talking about, immigration court history and court updates, really, and case law changes in that sense. So it's always fun, very interesting, and very educational for you to listen to because it affects all of us. So we're going to jump into that. But before we start, I do want to thank our wonderful sponsor, DocuWise, who's been sponsoring the magazine, the Toolbox magazine, and the podcast for a long time, maybe even years now, I think. They give extra 10% off their annual plan if you go to www.immigration-lawyers-podcast. No, that's not it. It's docwise.com/immigration-lawyers-podcast. You'll get a code, and use the code Immigration Lawyers Podcast. You'll get 10% off. There's a lot of neat information. They have articles in the magazine they put out too that talks about any updates they've been doing. And we do a regular quarterly with them. So if you use DocuWise, you'll see what the changes are. They have a really neat one coming up. It's a secret beta testing, but they'll come on the show and talk about it. It's really cool. But the magazine has updates there. So check out the video, that stuff. And if you want to try out the software, just give it a shot, do a test run and see if you like it or not. I'm sure you will. Other than that, I have a list of stuff I'm always supposed to talk about, but I forget all of them. Definitely check out the magazine. That's the most important thing. You're going to really enjoy it. If you're new or have been doing this for a long time, seasoned attorney, there's going to be a bunch of stuff in there you're going to learn. Just go to immigrationlawyerstoolbox.com/magazine and catch it there. Next issue, Kevin's going to be in there too, so definitely worth reading the next one. But the existing one's really good too. You're going to love it. I promise you that. Having said that, if you want to learn how to be an immigration attorney, a marriage-based immigration attorney, I have a full-on courses to get you there. With office hours and hand-holding, all that kind of stuff that you need. Just email me and we'll get it done. And I just jump on the show. Next time I have to have my list. I had a whiteboard. I have this where I'll read it off if I remember to look at the whiteboard. But I moved it out of the office. It was taking so much space. And it opened up a lot. Now I don't have the whiteboard to look to, and I didn't keep notes around me. So this show is really a loose-ended kind of thing, and just go with the flow. But Kevin, thank you so much for coming on again.
Yeah, I'm good. Are you sure you're good? You're getting your URLs wrong, and I don't know. Can we do this?
I gotta say, I've been doing this experiment where I've been waking up I try to go to sleep at 9, but it ends up being at 10. And I'm waking up, trying to wake up at 4, but end up waking up at 3:30. Keep looking at the clock. So I've been hitting 5.5 hours of sleep for 10 days now. And it seems like it's not enough, but I've never been so energetic in my life. This is right now like my 11th or 13th hour of work, and I'm gonna run with the kids for another hour. But I've never been so. It might be just because I'm really excited that I'm expanding my firm and all the stuff I'm doing with the magazine. But I don't know. Maybe I don't need that much sleep. We'll see how it goes if I crash and burn or what. But so far, I've been doing okay.
5.5 hours of sleep, waking up at 3:30. That's insanity.
Good for you. It sounds shocking at first, but the more I do it, it sounds like 3:30 is not that bad. But I remember people tell me I wake up at 6. They would tell me I wake up at 6. I was like, that's a lot, but 3:34. But I'll tell you, it's a magic hour. I get so much done from 4 to 6 today. Like by the time people wake up, I'm all done with the day, and I can just kind of relax. And it's not much relaxing the way I do it, but it's not like hardcore working on cases, just meetings and thinking most of the day after that.
No, fantastic. And I caught, for everybody listening, I mean, John and I just talked about me, submitting a piece for the next issue of the magazine. You got that right in there to hold me to it like 45 seconds later after talking about it. So don't mess with John.
Need content. I'm happy to have good quality content from top lawyers. So it helps the reputation that I can have.
Make it public.
So let's jump into it. What is going on in the circuit system and Circuit City, essentially? What's going on in the circuits and the BIA?
Thanks for having me on. I got 3 cases like usual, and I'm trying to focus on the good ones when I come on your show now, because who needs to talk about the bad? First is Oluwajana v. Garland, published by the 7th Circuit in early March. And, I always talk about the ones that, were in the last month. And, I'll give a shout out on your show too to Scott Pollock and Christina Murdoch, who represented Mr. Oluwajana. And it's just, as I said on the show, on my podcast, like it got me going from the onset, because really it's about being fair. Mr. Oluwajana essentially represents himself before the immigration judge. It seems like he wants to apply for asylum. It's a little weird with the immigration judge, and then the immigration judge orders him removed. He never files for asylum. On appeal, he gets these attorneys, and they file a FOIA with EOIR to get that record. and they immediately request an extension of the briefing schedule for the BIA not to set the briefing schedule, because once that gets set, you only have like 3 weeks. And the BIA ignored that. And then a couple months later, they set a briefing schedule, and they still don't have their record. They have no idea what's going on in this case. And in the BIA briefing schedule, they did not include the transcript, which just compounding the craziness. They usually include the transcript, as you know. And so they're running blind. They file a request for a briefing extension. The BIA gives them 3 weeks, and they still don't. And then they only get their FOIA response like about a week or even less before that extended briefing is due, and they file another request, and the BIA denies it.
Wow.
Even though, I mean, they just got the record. And then they file a late brief by only like a week, I think, and the BIA rejects the brief and dismisses the appeal. And the Seventh Circuit did not like that. And I mean, just to say the facts, as I said, the facts is to kind of, think it's a bit absurd and a bit unfair, although it does happen a lot. The BIA is very, very strict with granting another briefing extension, but it just shows how crazy the whole EOIR FOIA process is. And what's interesting about this one as a matter of law is that the BIA relies on the fact that they had given a briefing extension once before, and so they don't want to give another one. Mm-hmm. Even if that's proper, the BIA has authority to accept the late filed brief. And that's different than extending the briefing schedule, even the briefing deadline, even though it's like the same result. So I thought that was interesting. Even if they're going to deny a briefing extension, you can make a motion to accept the late filed brief. And the fact that they denied an extension shouldn't factor into whether they accept a late filed brief. So that was an interesting legal portion of that. The factual portion is, it's kind of a shot across the bow to the BIA, especially in the Seventh Circuit, that they have to be reasonable with briefing extensions and briefing schedules. But hopefully all of this is moot, which is another reason I want to talk about the case, because I'm not sure if you saw it, but EOIR now has an email address for every immigration court and the BIA where you can just request the record of proceedings.
Oh, I didn't know that.
It just started a couple of weeks ago. It's essentially a back end to the EOIR FOIA process. Mm-hmm. You just send them an email. They don't even really explain what's needed. It's on the EOIR website. I've done it 3 times now. I got a record of proceedings scanned to me by Orlando in like 10 days.
Wow.
Like no EOIR FOIA, no nothing. I got the whole record. The individuals in a month, they sent me that. They sent one packet for the removal, another packet for what was bond. Here's what the immigration court is looking at. Here you go. And I mean, that's just amazing. That's essentially discovery in immigration court. Hats off to the Biden administration, EOIR, for putting in these ROP requests now. And maybe I don't know, maybe Orlando and Miami, the places I've done it are quick because not a lot of people are doing it. And hopefully it remains quick even once people start doing it. But now it's been a godsend. It looks like you can't do it if you've also made a FOIA request for the record, because there is only one physical record, right? So if that physical record is at the FOIA center, it's not at the immigration court, and so they can't scan it. But it seems like the move in lieu of an EOIR FOIA, or at least the first thing to do before you do an EOIR FOIA.
I've been doing once a year, I'll do an EOIR FOIA, and they're coming out pretty fast. Like within a month, I was always surprised. They send a CD, which I have to get a separate CD player that connects to the USB drive just for those.
Yeah.
But they're pretty fast. I'm surprised in this case that they're taking that long.
That's not been my experience, and at least recently. EOIR FOIAs have been taking many, many months, like 6 or 7 months. Wow. I understand that the record center, actually, wherever they keep, especially the old cases, my understanding is literally it shut down over COVID. And so no one was going into this building to get files. You could not get a file. And so now it's back open, and they're backlogged, and COVID.
Just a note, like there's a cave or something like that was shut down. All these NAS cases that couldn't move forward. It was a mess. They opened it up. But my USCIS FOIA was after that lawsuit that happened over delays. That was successful. I'm getting USCIS FOIA responses like in 30 to 60 days. It's wonderful. It's fun to see. But then they're coming back where like I know there's more documents and they're not in there. In the case, I didn't complain about it because I knew the case as a backup. But like there's a bunch more documents and there's all this stuff I need. That was the files I even sent. I'm trying to see what they have and they're missing. So it's not a clean system.
No, we have identified 500 pages. 100 of them you cannot get.
Yeah.
B6, B7.
Another annoying thing is they're doing is if you do a marriage case, they in the petition does a FOIA, they'll say this belongs to the beneficiary, won't give it, and then we do the beneficiary request and it's all redacted. And it's like, well, how are we going to get it? Like it's like none of this makes any sense. But that's U.S. So what is there more to the case on this one?
No, I mean that's about it. They said that the Seventh Circuit sent it back. They said you got to consider their brief, and what you did was unreasonable. The BIA got some facts wrong. The whole thing is a bit of a mess, but it's a unique case, and there aren't that many cases, right? That by the circuits slapping the BIA's hand, requiring that they accept late filed briefs, talking about unreasonable delay, the BIA's duty to provide FOIA records. So it's a good case. It's a good case to have in your back pocket. Hopefully it all becomes irrelevant if we're going to do ROP requests now, but it's a good case to remember there. I like it.
And also, thank you for reminding me of Scott Paul. I got to talk to him like 9 months ago about doing the magazine and the podcast, and I kind of lost track. I have to reach out to him. Great guy. He's in Chicago, right? He does a lot of hardcore immigration work.
Yeah. Hence the Seventh Circuit, I guess.
And then the circuit numbers, I got to look at a map every time we're talking.
Right.
Seventh, which one is this? I probably should read it off for viewers too. Seventh Circuit is these places.
Right. I forget that I have this weird niche knowledge now, being a circuit watcher, where like I can tell you things about the circuits that you don't even want to know. I can tell you the times of day that every circuit is going to publish their decisions, and that is something that no human being needs to know. No one needs that information.
One thing is maybe just an idea for your show is, so we have a new nominee for Supreme Court, Ketanji, I don't know, Phillips, I can't remember.
Jackson.
But what's that?
Judge Jackson.
Yeah, Jackson. If there's access to look at her immigration history on how she came analyzed, that'd be neat. But I don't know.
So I think I agree, and I think I would have done something like that, but. So there are some entities that have done that, either AILA or AIC or both. The thing with her, though, is that she was a district court judge for like 6 or 7 years, and they don't get that many immigration decisions. Yeah. And then she was an appellate judge for like a year or a bit more, but she was on the DC circuit, so they don't really get immigration decisions. So I think she's a bit of an open book on immigration. I think that's the idea with her.
I thought DC would get a lot because like open-ended. At least they used to send a lot of the APA and administrative process lawsuits.
Yeah, you'll get an APA. They have some APA challenges in the DC circuit. I don't think she was on any panels. So again, she was only there for less than 2 years. So I don't think any of those big ones came up to her.
Very interesting. We'll see how that goes. I'm not really keep track of what's going on, but do you know, is she going to get chosen or elected?
It looks like she's getting through. It looks like Senator Murkowski, Senator Romney, and something like that. Don't hold me to it. And Senator, what's her name from Maine? It looks like she's got 3 Republicans and all of the Democrats. Maybe Sinema. I don't know.
Yeah. Well, we'll see. Is Sinema the one from Arizona?
Yeah.
When I was younger, I was like so into politics. I knew all their names, but now more and more, I'm like, forget these people. I don't want to even think about these people. Run our lives. But okay, so what's the next case?
The next case is Julmice v. Garland from the 4th Circuit at the end of March. And this one and the next one are both from episode of 100 of the podcast, which is crazy.
Which is a reminder that this is, you do a full in-depth review on of the list of stuff I'm supposed to say at the beginning of the episode.
You don't have to say that.
Yeah, they do. It's important. So one disclaimer, this is not intended for individual legal guidance, which I always forget to say, but more importantly, Immigration Review Podcast is one of the top immigration podcasts out there. I'm lucky to say number 1 is usually that Immigration Toolbox, but it's more topics, so it's very more niche. For a super niche topic like yours to be pretty much number 2 up there and you're sometimes being number 1 is just testament to how hardcore your fans are. You must have like a dedicated audience that goes to every episode and gets your numbers up. But check it out, Immigration Review Podcast.
I got you. I'm happy to be number 2 to you forever. That's fine with me. I just want to beat the ones that are about like immigration news, immigration gossip. I just want to beat them. Like they don't. We got immigration law. That's what we should be on top. That's what I want to be. Make sure.
I have this issue because on YouTube, like my channel is growing. I have like 12,000 subscribers on the YouTube channel, and this and that. But it get decent views. I get business from it, but like it like to get views, you got to talk about the gossip. And like one thing is there's a new bill that passed through Congress. It's probably never going to happen, or if it does, who knows what it's going to look like. The Starter Act, like they're going to try to keep these visa numbers or something like that. Have you pay extra money so that you could deal with country limitations or something. But like you get so many views when you talk about it, but it's like clickbait. Like, and I see people get views, but I'm like, I don't want to do that. I just want to talk about this is what happened. This is USS did this. We know what things we know. I don't want to talk about maybe DAPA will come back. Maybe it's like, okay, like it's yanking the tail of the audience. So, but it will get more business probably. So maybe I should just do it. I don't know. But I hear you when you say that. It's not gossip. It's just about, hey, what are we doing? How do we get this business and law going?
Stay pure, John. Stay pure.
It's like these artists who are that don't want to sell out kind of thing.
Yeah.
You ever listen to Tool? No. Yeah. You know, he has a song. It's great. It has a really awesome intro, but he's like a kid goes up to him and say, "You guys sold out." He's like, "Dude, I sold out way before you even knew my name." So what do you say? You know what song I'm talking about?
I don't know. I don't know that, but I can't imagine telling Maynard that you guys sold out either. So you know, Tool rocks. I disagree. They didn't sell out.
No, just like it's called. I think it's the end of my album or end of a song. But it's if you're into music, that song is just off the hook, the instrumentals and stuff. But this kid comes up to him, they call themselves. Like, dude, like you don't even know how else to get where we're going. You have to do a million different things to get the system going. But he was actually a guy was on was it him on Joe Rogan's podcast? Really interesting. He's into wine now and stuff. It's really random. But he's like a wine guy. But sorry, go on that tangent. But so sorry. So second, it's Fourth Circuit. You're saying?
Yeah. Well, I mean, if Maynard's into wine now, I mean that is kind of sellout for heavy metal. But I'm also into wine, and I love Tool. Julmice v. Garland, Fourth Circuit, and we can talk about this because I really the holdings are what's interesting. This one, it's amusing. I enjoy it. It's statutory text, so it's always fun.
Yeah.
A 237A1H waiver is an immigration court waiver, essentially for LPRs who got their green card through fraud. It's usually how it works.
Let's talk about this. This is a really important subject. It took me like 5 years of practice. I was randomly at an AILA conference, and someone mentioned this. I'm like, oh my God, there's a thing called 237A1H.
The best.
It's incredible. So like, imagine you get your green card based on like being that unmarried adult child of a green card holder, but you're really married. If you get the green card, they put your removal for that, and you're at that point have a qualifying relative, they could just fix everything up as if nothing happened.
So that's actually exactly what happened to Mr. Julmice. That is what he was. He came as the unmarried child of a U.S. citizen into the U.S. and he was married. We see it a lot with marriage fraud, which of course you don't condone, but it's available if you are otherwise eligible for a green card. You don't have maybe convictions and all that stuff. It's a waiver, and it doesn't have a hardship component, unlike pretty much every other waiver component under immigration law after IRIRA's change in 97. So it's a favorable waiver, but you do have to have a qualifying relative, a U.S. citizen or LPR, I believe, parent, spouse, or child. Yeah, all three qualify. You just have to have them.
Yeah.
And then it's up to the judge, like as a matter of discretion, like old 212C. It's just, balancing and weighing the factors. Well, Mr. Julmice came as the unmarried son. He was married, committed fraud, put in removal proceedings, flat out 237A1H fact pattern. But his father dies either during removal proceedings or beforehand. And so that was his only qualifying relative because he didn't have U.S. citizen or LPR children or a U.S. citizen or LPR spouse. And I guess his mom wasn't a U.S. citizen or LPR. And the Fourth Circuit said, it doesn't matter. You just have to be, and the text is important, so let me read it. The waiver is available to a non-citizen who is, quote, the son or daughter of a citizen of the United States.
Incredible, yeah.
And the Fourth said you remain the son or daughter of a U.S. citizen, even if the U.S. citizen is dead. I mean, the focus is on the non-citizen, not the parent. And so
incredible.
Mr. John and the oil was saying, well, this is all about family unity. This is ridiculous. And the Fourth Circuit said, citing Dinesh Chavez, we don't care. The statutory text says what it says. Now they quote, and so it's very amusing. It also is contrary to matter of Federico, where the BIA apparently in 2008 said the exact opposite. So, that's not good law in the Fourth Circuit. And here is your guidepost to challenge it in all the other circuits. And let me just look at my notes. It looks like the Ninth Circuit has ruled similarly. So it looks like the Ninth and the Fourth, you can have a dead parent and still qualify for 237A1H. As I said on my show, God, I see, God forbid, but I see no reason why the same rationale based on how the statute is written wouldn't apply if you have a child who passes away, which obviously you're not wanting. But if it happened, it looks like they'd probably still be a qualifying relative, maybe. Although the Fourth Circuit said this doesn't count if you have a divorced spouse because of the way it's written, that a divorced spouse is no longer a spouse, is what the Fourth Circuit said. So not the same logic. Although I think they're a bit unclear if your spouse passes away. I mean, if your spouse passes away, is the spouse still your spouse? They seem to indicate no, but it's there. Anyway, wonky, interesting case. If you only have one qualifying relative and that qualifying relative passes away, don't commit fraud to get your green card. But if you do, 237A1H.
And the cool thing about it is once you keep your green card, like it's as if the green card is never taken or anything like that. So your admission date's the same. You could, because a lot of times this issue will pop up when people do naturalization pro se in particular, and they discover it. So they go to court, fix it. They could turn around and file for citizenship right there. They keep the 5 years and no history, all that kind of stuff.
Yeah. So not legal advice. I'm almost positive that yes, that USCIS can't, say you're not lawfully admitted if an immigration judge has said otherwise. I would have to do more research though on, would it indicate bad moral character if the fraud was committed within 5 years, for example? Could they try and get around it? Because yes, you were admitted. Yes, this was waived, but we still think you have bad moral character. Could USCIS turn around and do that? I'm not sure. It would be a lawsuit. USCIS is going to do USCIS things. At
the very least, you retain the initial admission date. So when
absolutely,
you don't have to wait the timing period for citizenship. I never needed a handle case. I never will, because I'm not going to take a case that has these kind of, have one or two that may have this situation. But I got so fascinated with it. I spent a godly amount of time reading every single circuit case that ever existed on 237H and its predecessor statute for a couple months. And I had this 150-page ebook I wrote. And then I came to proofread it, and I was like, I'm going to throw up if I read this one more time. And it just sat there. I was going to give it to Sabrina Damas to do it, and then I just lost track. So it's there and probably outdated, but every single case, and I was like, this is such a fascinating statute. The history had to do with World War, and like people had like war experience, but they didn't admit to it in the case. And like I was like, damn, this is so magical to have this. It's a weirdly statute too, because it says like, obviously there's fraud, and there's a thing called if you didn't do a Department of Labor or something properly, it's like a double thing that they watch out.
I'm not so familiar with that component. We do the 237A1Hs a lot. Those are the type of clients that we do often get. I'd be interested. I can't believe you wrote a 150-page.
Essentially, I copy pasted every case, and then I did an IRAC each one that ended up being 100 pages. Then I'm like, this is not legible. I have to create some sort of this and that, and then by that time, after like 100 hours into it, I was like, okay, I can't do this anymore. I just let it go. It's like 8 years ago or something. Because there was issues about like the statute says it's for people, essentially it words it in the way that looks like if you did consular processing, you could do it, but not if you did adjustment status.
I disagree.
And so that was the whole thing.
Yeah, you can do adjustment.
Yeah, there was a BI decision, that kind of said that, but the way the statute's written, it's made it sound like it. So that was an argument for many years, like, oh, you didn't adjust, it doesn't work for adjustment. If you did admission like it does, but they said it's all the same. Like these word things don't make a difference. So very fascinating. This immigration law has so many like little things. You can make a career off 237A1H. Just like market that and then travel the country arguing this fact pattern, and you can make a 6-figure salary probably if you just put your stuff out there.
It's a dangerous thing though too. I mean, because no immigration judge is going to grant a 237A1H waiver unless you admit what you've done. Some people don't believe that what they've done is committed fraud, and some people don't want to admit it. And you're putting yourself out there. It's discretionary, so it's dangerous. But if you've done it,
some people have gone around with they like because when I was researching, I was asking people. Some people say we don't admit, and the judge just lets it go. But it is like you have to say what the fraud was in paper, but some people like we let it go, but it's going to be like the judge just doesn't care enough. But yeah, for the most part, that's something you have to like put it out there so you can take it back. But random lawyers have said we've done it without that. But it's just one of those things that it's always different kind of thing. There's always niche, or not niche, but not examples of whatever that incidental stuff that happen like that.
The last case then is from a decrimmigration, as I always like to go without getting too much into the weeds. And that was not pun intended, but I wish it was, because it is on the weeds. It's Syed v. U.S. Attorney General out of the 11th Circuit. Shout out to David Stoller in the Central Florida area for this win on the big issue. That is the huge issue that the 8th Circuit said in Gonzalez v. Wilkinson, that the board said the other way in matter of Guadarrama. Florida's possession of marijuana statute crime is not a removable offense. It's not a law relating to a controlled substance. And that is because Florida's definition of marijuana is broader and covers more conduct, covers more plant than the federal definition. That's because Florida criminalizes technically possession of the seeds and the stalks of a marijuana plant, and the federal government doesn't.
Oh, really?
And even though there is probably no case where Florida has punished it, and who knows, no one can find it, Judge Choflat, who is no progressive on criminal immigration issues on the 11th Circuit, Judge Choflat authors the decision, says, we don't care in the 11th Circuit if the statutory text itself is clearly overbroad. You don't have a categorical match, and the realistic probability test, and the need to find a case where the law is applied in an overbroad manner, it doesn't apply. And so Florida's definition, that is the text, marijuana, is overbroad. It covers the stalks and seeds. The feds don't. Case closed unless Florida's definition of marijuana is itself divisible. That is, possession of, I don't know, the marijuana, the flower is different. God, I'm such a loser. Well, the marijuana flower is different than the marijuana stock, and it's not, because I mean, of course it's not. And so it's a huge decision for non-citizens in the 11th Circuit, possessing marijuana, all that. So for both relief, this is in the relief context too. So it's not going to preclude you from relief, and it's not going to make you removable, for example. But it's also big because there's been this whole argument in the 11th Circuit in whether or not its seminal decision in Ramos v. U.S. Attorney General, which is a Kurzban law firm case, whether that is still good law. And the board really went out there in matter of Guadarrama in 2019 and said, the 11th Circuit, it's not good law anymore. The 11th Circuit doesn't follow it. And I didn't think that was right. A lot of people didn't think that was right. And in this decision, the 11th Circuit's making pretty clear that, no, Ramos is good law. You don't need to find a case if the statutory text itself makes the statute overbroad. And so it's a huge decision in the 11th Circuit. Props to David Stoller. It's been an argument that a lot of people, Mike Vastine, Mary Kramer, a lot of people have been arguing for a long time. And finally, the 11th Circuit bit.
Very good. Very good. I mean, especially that area of Florida, there's going to be a lot of people getting helped by this. This is good stuff.
The whole marijuana dispute is a bit silly to me. I mean, you got the House decriminalizing it for the second time, but it's not passing the Senate. I mean, everything with marijuana seems to be changing, but until it changes federal, it is just a grenade for non-citizens who do it, who smoke marijuana, possess marijuana in a state where it's legal, even if it's legal there, it's still a grenade for immigration purposes. So hopefully
if it's legal here, if it's illegal in your country and you get caught, that's still like going to be filing the crimes there. So
that too.
It has to be a global kind of thing that pops up. If you got a caution in the UK for it, for example, that's going to follow you as a conviction. Yes,
but I feel like if the House has decriminalized marijuana, but it's not going to pass the Senate. But if it does pass the Senate, if marijuana is no longer in the Controlled Substance Act, then I believe that would probably make it no longer a removable offense. So it wouldn't matter if you got it in England or another place because it's not a removable offense here. I think that's how it would work. Hopefully, I mean, you got to take it out of the CSA, and from there, all immigration results follow.
Yeah, it goes out to my experience, but then they also could get you for a year for. I guess they can get you for like the health reasons that they get you sometimes. So that would work either.
I
So
guess
hopefully
it
that's
could
the
get you
case,
for
man.
health.
Because there's some people like have like very minuscule marijuana convictions or minor stuff, and then they're like, oh, immigration crashes. There's like this famous case of this Israeli scientist that was a scientist on marijuana, and he did a marriage adjustment case, and it was denied, and he was removed because he was a scientist in Israel on this stuff. That was in the news and stuff. So it's like the permutations of it are pretty drastic. He didn't know. He thought, I'm a scientist. What are they gonna do? Like, nope. It's black letter law. It's like open and shut. You're out. Well, good stuff. Thank you so much for coming on. Check out the Immigration Review podcast, wherever podcasts are found. It'll be there, and get really, your fix of this kind of stuff. If you're either in this field doing court-related stuff or things that match it, immigration, asylum, all that stuff, you have to listen to it. Or if you want to learn about it to get into it, it's like essentially Kurzban Part 2. It's a live Kurzban book right there.
Oh, you honor me. And Ira's book is dropping soon, so there'll be a new edition of that too. So Kurzban Part 1, alive and kicking, and much more important.
And I'll plug Ayla and Kurzban. Like, get your pre-orders. And my associate sent this. Like, well, we got to get the pre-order in to save $150 or something like that. So definitely get that in. It's coming up every 2 years or so, right?
Yeah, I feel bad for Ira. Ira does that. Ira does that book. Like, Ira does the book. People think that he doesn't. He does. And like, he killed himself to get all of those Trump changes in for the last edition that came out in 2020.
Mm-hmm.
And now a lot of those changes are gone. I mean, he had to do it, but it's just that is such a burden. It's such a big thing what Ira does.
I mean, at the level I do, where I'm constantly in the news, it takes all the time. I imagine he's from morning to night thinking about this stuff. That's just all his life. Yeah,
he's in it right now. So whatever you eventually see when it's published, you'll know that it's happening right now. This is a lot of his labor.
He's been on the show. He was actually my issue on episode 100. Actually, put the title together. So might have him back on when that time comes. Maybe have the magazine talk about, just so people get an idea what's going on behind the scenes of something like this, and maybe someone could ghostwrite it, because I'm sure he's burned out from writing and stuff like that.
He's always happy to talk about Immigrants List, which is the political action committee that him and Sui Chung and a lot of people. It's getting big. They donate to senators and Congress people for immigration reform, for fair immigration action, and they're always happy to talk about that. Maybe that could bring them back.
Yeah, definitely. I'll connect with them. I'll reach out to you guys. I got this magazine together, avoid all these delays in publishing, but we'll get it out. So thank you so much for coming on. Check out the magazine, immigrationlawyerstoolbox.com/magazine. Issue number 4 is wonderful, a lot of information. And check out the upcoming summer one that comes out with Kevin Gregg.
That's right.
Thank you all for listening. Immigration Review Podcast is just type in Kevin A. Gregg. You'll find him out there. Thanks so much, bro. Good to see you again.
Thanks, John. See you next month.